Thank you for your patience. We have reestablished connection with the WebEx. The time is now 9:03 and we are ready to resume the meeting. So I believe where we left off, we have now been able to review the form that was referenced. It has been emailed, and we were looking at Patrick. I was asking, does anyone have comments? I think Todd was going to say maybe something before then, but the question for council is, does anyone have any comments around Council Members Condon suggestion from would to will? And then Vice Chair Howe has something.
I agree with her comments and that it should be will instead of would. So I'm there.
Thank you. Anyone else? I see some head shaking. And so I'm just looking over at Councilor Rowe, and if there's anything he would like to comment.
Yeah, I would just add that assuming that council approves of that change, it would be subject as any site certificate. If something changed in the corporate structure, then they would need to come in for an amendment anyhow. And so changing from would to will wouldn't change that. They would still, if for some reason Capital Power was no longer considered the parent company, they would need to come into council, inform you of that, and potentially need to get an amendment to the site certificate. And that is true regardless of whether you use the word would or will.
Okay, thank you. Councilmember Condon, does that alter your opinion at all in making that change?
No, confirms it.
Okay, thank you. Councilmember Byer.
Just an observation. I think this is the first time we've seen this kind of letter and guarantee, and I think it's something we may want to consider in future site certificates to address some of the concerns we've had about the relationship between parent companies and subsidiary. And while I'm doing this, I just want to thank everybody who's spending part of their day with us. We know these processes are long and complicated, but we appreciate your taking the time to participate. It's really important for council members to get your feedback and to see your interest in these big projects. So thank you.
Thank you for your comments. And I'm remiss, I would like to announce that we do have the commissioners. I don't know if it's all of you, but I believe so. The 3 commissioners from Umatilla County present. So having you here in your own area to represent the county, we appreciate you being here. Thank you. Okay, so we have, I think, agreed that would to will would be preferred for us as council. And so Kate, you can, so now the next issue, I guess, is with that change, are we as council fine with what has been presented, or if there's anything else? Councilmember Condon.
Thank you again. Just a quick question with respect to the guarantee we just received. Is that attachment F with the department's legal counsel after consultation, or?
Yep. Councilmember Byer asked the same question when we were on break. So attachment F is the form that we've already approved. If they use that form, they're good to go. If they would like to make changes to that form, then we would need, I along with the department would review that and need to approve it.
Thank you.
Thank you. Vice Chair Howe?
Yeah, I agree with the findings of fact, conclusions of law, and conditions of approval in the proposed order.
Thank you.
Condon, I do as well.
Thank you, Secretary Cornett.
Sorry to interject. So I'll kind of go back to it. Doesn't have to be as formal as like the vote.
Okay.
So I don't know if we technically even need a motion second. So my plan was to simply read what I believe your direction is, and then I'll call roll if that works for everybody.
Okay, thank you.
Okay. So what I have based upon the conversation was agree with the proposed order, findings of fact, conclusions of law, and conditions of approval with the following changes. So on the slide, there was the bullet, and I'll read the language. Capital Power Corporation as the parent company to the LLC is the entity that and would strike would and add will fund the construction, operation, and retirement of the proposed facility.
I see heads nodding, so we'll say yes.
So that would be the sole change on the organizational expertise, findings of fact, and conclusions of law, conditions of approval. Okay. Ken Howe,
Yes.
Ann Byer,
Yes.
Richard Devlin,
Yes.
Jordan Truitt,
Yes.
Cindy Condon,
Yes.
Marcy Grail.
Yes.
Okay, that doesn't pass. That's just a straw poll. So again, this would then be carried forward into the final order language.
Okay. Well, thank you, council. For the record, this is Kathleen Sloan again. At this point in my presentation, I'm going to stop and I'm going to turn it over to Assistant Attorney General Aaliyah Miles, and she's going to present to you on the proposed contested case order and the and then the exceptions hearing. And then I'm going to come back for item 1B. So thank you for your time.
Okay, good morning, Chair Grail, members of the council. For the record, I'm Aaliyah Miles from the Oregon Department of Justice, and my role today is to advise the council in legal matters related to this portion of the Nolan Hills project contested case hearing and the exceptions in particular filed by the county. Patrick Rowe, my colleague at DOJ, has been representing the Oregon Department of Energy in this contested case. And for some years, and you're probably aware of this, it has been the department and the council's practice to have separate counsel represent the department and the council once an application has proceeded to a contested case. So that is the case here. That is why you see me, a new face, instead of Patrick sitting in this chair. This separation is not required by statute. It has just been a practice. And my role is basically just to be a resource to you, to the council, to answer questions that may arise as you hear from the parties. I'll sort of kick things off by reviewing the contested case and what the hearings officer decided here before we hear oral testimony on the exceptions that were filed and any responses. Odo staff walked us through how we got to this point on this application for a site certificate. And before I turn to the contested case in this matter, I did want to review just a couple other preliminary items. One is that, ordinarily when someone asks their attorney for advice that is confidential, attorney-client privileged, as you know from other processes, the council's practice has been to, at times, and this is the council's choice, waive that privilege and seek advice from the person sitting in the chair I'm sitting in this public setting. That is always council's choice. And so if you, at any point, any of you wish to have a privileged conversation, you can indicate that somehow. But I did just want to flag that. So we'll spend about 15 minutes reviewing the contested case phase of this project application. And then I think our schedule has a short break before we proceed with the exceptions hearing. I guess the only other preliminary thing I wanted to say is to please stop me at any time with questions as I'm reviewing the contested case hearing portion and order. And I would also ask that Odo staff and others feel free to stop and correct me should that be necessary. I have come up to speed on this project, but I know there's no replacement for living with something over time. And so in the event that I misstate or say something confusing, please feel free to chime in. Okay, so I think with that, go to the next slide, please. Okay, so just for this preliminary portion of the what I'll be presenting on is just reviewing the contested case proceeding that has occurred, who the parties are, the issues, and the order from the hearings officer. Okay, next slide. As this slide shows, the big milestones in the contested case are listed here. It was in August 2022. There was a note. The department issued a notice of proposed order. An opportunity to request a contested case. You just heard about all the other portions of that proposed order that, all the other standards. With regard to the land use standard, the Umatilla County petitioned for a contested case. The hearings officer was assigned, and the dates to the right show that August to April of this year, that contested case proceeding has been ongoing. The proposed contested case order was issued in May of this year. Umatilla County has filed exceptions to that proposed contested case order. The applicant and department have responded. And so today is your opportunity, the council, to hear from parties in a way that supplements the written materials that you've had, that you received a couple of weeks ago, and consider the issues that have been raised. Okay, next slide. So as mentioned, there's Umatilla County is the party that requested party status, limited party status for this contested case. The Department of Energy, as the staff to you who recommended the proposed order, has also responded, and the applicant as well. The issues that Umatilla County articulated as the basis for joining as a limited party in a contested case are placed up there. We're going to see it presented in different ways during the exceptions hearings, but for the purposes of the initial request for a contested case, Umatilla County asked to raise the issues that you see there. Number one, that the counties acknowledge land use regulations in what I'm going to refer to as Criterion 3, so that you don't have to hear me read that entire rule ordinance name. Land use regulations in Criterion 3 requiring a 2-mile setback between wind turbines and rural residences on EFU zone land are applicable substantive criteria within the meaning of the council's rule that apply to the project, and that the project does not comply with Criterion 3. So that was issue 1. And number 2, that the project is required to obtain a conditional use permit from the county. I think we dig into those a little bit more on the next slide. So let's go to the next one. So the way the issues were framed for the contested case are here. You can see issue 1, again, is really stated in its most simple terms. It's whether the county's land use regulation that I'm referring to as Criterion 3 is an applicable substantive criteria within the meaning of EFSC statutes and rules that apply to the project. issue 1.1 is a sub issue because you only reach it, the hearings officer only needed to reach it if the conclusion to 1 was that criterion 3 was applicable substantive criteria. If it is, whether the project complies. Issue 2 that the hearings officer considered is whether the project is required to obtain a conditional use permit from the county. Next slide. So you can see here, and you have the proposed contested case order analysis. You have the order in your materials. You can see here sort of some highlights pulled out with regard to the hearings officer's conclusion on issue 1. What's important to understand is that the hearings officer concluded that that in this case, criterion 3 is not an applicable substantive criteria within the meaning of the council's governing statutes and rules. The reason for that is that essentially, I'm just looking for the rule language here, that the applicable substantive criteria, in order for a local ordinance to rise to that level, it needs to be one that is required by statewide planning goals. And here, the emphasis also in the hearings officer order is that definition of applicable substantive criteria should have the same meaning throughout the statutes and the rules. It may be used in slightly different ways, but for purposes of clear legal interpretation, should be given the same meaning in all of those contexts. The hearings officer concluded that the criterion 3 is not an applicable substantive criteria because it is not required by the statewide planning goals, and therefore does not apply to the project. Next slide. Issue 1.1 is sort of the sub to that umbrella issue 1. And the question was, if so, whether the project complies with criterion 3. Goal 2, the hearings officer analysis, conclusions of law, presented that the project does not comply with criterion 3, but otherwise complies with applicable statewide planning goals. So I think we'll come back to that goal 2 bullet later, but the real important piece here was, no, it does not comply. The project does not comply with criterion 3, but otherwise complies with applicable statewide planning goals. Next slide. On the issue designated as issue 2, the hearings officer reached the conclusion that the applicant is not required to comply with criterion 3 in order for the county to issue a conditional use permit. Again, it really, this is a slightly, different angle on the same issue, because criterion 3 is not an applicable substantive criteria for that same reason that the project can meet the land use standard in the hearings officer's opinion by compliance with statewide planning goals. It also is not something that the county must issue a conditional use permit for in this context. And so applicant is not required to comply with that in order for the county to issue the conditional use permit. Next slide. So at this point, I wanted to just sort of back up a little bit and just put in context a bit. So the issue statements that we reviewed and the ALJ's conclusions are important for you to understand well before we turn to the county's exceptions. So I want to make sure that we take that time, and if you have questions, that we go over them. From a big picture perspective, I think it's important to recognize that the contested case here was on this one fairly narrow issue within the land use standard and with regard to Umatilla County's ordinance. The proposed order did address some of these same issues because they had been raised by the county in the draft proposed order. And in the contested case process, the hearings officer, in recognizing that these were essentially issues of law, has styled the contested case order as a determination on motions for summary legal determination. So in this case, the parties have all had opportunities to file opening briefs in support of a motion for summary determination by the county on these issues, as well as responsive and reply briefing. And this ALJ and the order that you've reviewed, it was based on that cycle of briefing that the ALJ reached the conclusions that we've just gone over. Essentially, the conclusion that the ALJ reached was that, that essentially the proposed contested case order agrees with the department and the applicant. I think the easiest way to kind of back up and understand the approach taken in both the department's recommended proposed order and this hearings officer order, which agreed with the underlying order, is that there is sort of a belt and suspenders approach in the sense that the sort of governing finding on the issue is that as a matter of law, criterion 3 is not an applicable substantive criteria under both ORS 469-504 and the OARs because it is not required by the statewide planning goals. When applicants, when applicable substantive criteria are identified by a special advisory group for purposes of review of an application on the land use standard, the ordinances that are put forward often have been required for that jurisdiction to adopt in order to comply with statewide planning goals. So you don't often see this analysis that's happening here about whether an ordinance is required by a statewide planning goal. But I just note, and the underlying orders also note that that is in fact, central to the conclusions that the hearings officer reached here, because the statutory language is quite clear that the applicable substantive criteria required by a statewide planning goal is sort of, that is how that term is defined. And so that is just a little bit of additional context, and that the belt part of the recommended contested case order is that conclusion number 1, that this isn't an applicable substantive criteria. The suspenders is that in the alternative, the hearings officer also felt that it was prudent to recommend that the council find that even if criterion 3 is an applicable substantive criteria, that that this project application nonetheless complies with statewide planning goals under 469-504 1 little b, big B, and subsection 5. You'll be hearing about this from the parties, so I'm not going to go into additional detail about it. But I just wanted to sort of frame it for you as a sort of a finding and an alternative finding. And the exceptions hearing that we're going to go through also tracks those same alternative findings. So does anyone have questions from the council?
Thank you. Questions, anyone? I see heads shaking here. Jordan, you okay? You have any questions? I know he said he got dropped off again, so whether.
He just gave thumbs up.
Okay,
Yep. Nope.
thanks. Oh, I
I'm
see.
good.
All right, thank you. Secretary Cornett.
Madam Chair, before we go on break, just want to make an announcement. For reasons that I'm not going to go into, we're going to continue to have issues with the WebEx today. For some reason, it's going to time us out about every 40 minutes. It should only take a couple of minutes to reset and go back on. So my apologies for this technical problem. For those in the room and those online, just recognizing that it'll probably just abruptly end. Nancy will be tracking that. We will cease, any of the activities that are going on, and then we'll resume as quickly as we can.
Okay. So thank you for that, that warning. And I would just say that this is one of the downsides to a benefit. More people are able to participate by our hybrid options, and we just have to accept some of the unpleasantries that go with it. So, is there anything else that you have at this time?
I don't think so. I think we're scheduled for a break before we move to the next portion.
Okay, council members, any questions before we break? All right, well, the time is now 9:29, so we'll be extra generous. Instead of 15 minutes, we'll go at 16 so we can resume at 9:45 a.m. We are now recessed. Thank you.